Mic check, mic check. Mic check for the reporter.
Testing, testing, 1, 2, sound check. Testing, testing, 1, 2. How's that one?
The Subcommittee on Regulatory Reform, Commercial and Antitrust Law will please come to order. Without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome here everyone, and particularly particularly our witnesses supporting international antitrust enforcement, China and beyond, and I now recognize myself for an opening statement. You can tell I wasn't prepared for this. We convened today's hearing to examine the enforcement of competition laws across the globe, but with a focus on how China is enforcing its laws. This focus is a result of troubling reports that China may be using its competition laws, or if you will, its antitrust laws, to advance industrial policy at the expense of America and other foreign companies. We will also examine how the executive branch has responded to China's administration and its competitive laws. Over the past 30 years, China's economy has experienced remarkable growth, increasing at a rate for many, many years, year over year, stated to be at 10% per year. During that time, China has become an important trade partner to the United States and a significant influence in the American economy. Between 1990 and 2015, total trade with China rose from $20 billion to $600 billion. And just last year, China passed Canada as the United States' largest single trading partner. China is the second largest U.S. agricultural export market, the third largest U.S. merchandise export market, and the fourth largest U.S. service export market. In total, China is estimated to be a $400 billion market to American companies. Well, these statistics provide stark numbers. One need only look no further than the labels on phones, toys, cars, clothes, and a wide array of other consumer products to see a familiar marking, made in China. To understand the pervasive impact of China's economy in the United States. As China's economy developed, so did its laws and regulations designed to foster future growth. In 2007, China enacted its competition laws called the Anti-Monopoly Law, or AML. Since the AML's enactment, there have been troubling reports of China deploying the law in a manner that violates international norms of due process, with the result of prioritizing the advancement of China's industry policies over promoting competition. These reports include allegations that China prevented foreign lawyers from representing their clients before competition authorities, threatened foreign executives during the course of competition investigations, targeted foreign companies more frequently than Chinese companies with respect to merger remedies and conduct investigations, pursued the extraction of intellectual property at below market rates, and sought remedies that directly benefited the Chinese industry. Given the size of the Chinese economy and the importance to American industry, these are serious allegations. Following these reports, the executive branch has responded in a variety of ways. Notably, the Commerce Department has engaged with China through the U.S.-China Joint Commission on Commerce and Trade, and the Departments of State and Treasury similarly engaged in the U.S.-China Strategic Economic Dialogue, which is taking place this week in Beijing. Past meetings with U.S. officials have resulted in non-binding voluntary commitments by China to improve transparency, increase due process, and enhance the fairness of the AML. We should ensure that U.S. companies are treated fairly, consistently, and objectively by international jurisdiction. Today's hearing will help inform the committee regarding international competition law enforcement, particularly China, and whether other countries are influenced by China's use of the AML. Additionally, the hearing will update us regarding how the executive agencies are coordinating with each other and engaging with China and other countries on the treatment of U.S. companies and citizens abroad. On a personal note, I was an electronics executive during the era in which many American companies found themselves moving abroad, often to Taiwan, the new territories, and then into mainland China. And during that era, this was not the law, and yet there was inherently a desire to build a future China. And to this, on a personal note, I want to build a better China, and commerce is the answer. But it's only the answer if, in fact, they embrace the international norms that allow them to win when they're competitive and choose other vendors when, in fact, the most competitive vendor comes from somewhere other than China. I look forward to today's discussion and our excellent panel, and it's my honor to recognize the ranking member, Mr. Johnson of Georgia, for his opening remarks.
I thank the chairman. Today's hearing is a welcome discussion of international antitrust enforcement with a specific focus on China's approach to competition policy under its anti-monopoly law. Over the past several decades, one of the most profound developments in antitrust law has been its expansion into the global economy. In the 1980s, as few as 5 countries robustly enforced the antitrust laws. Today, more than 100 jurisdictions are members of the International Competition Network, an organization of enforcement agencies. This growing interest in antitrust law reflects a broader trend that reflects nations moving away from centrally planned economies to open markets. In recent years, there has also been some divergence from the U.S. approach to antitrust enforcement among nations with established competition authorities. This change is particularly evident in China's aggressive enforcement of its anti-monopoly law, which includes both pro-competition goals such as preventing monopolization, and non-competition directives such as improving economic efficiencies and development in China. Some have suggested that these twin goals have at times served to protect domestic commerce rather than promote competition. Examining these differences is important because local enforcement decisions can have global effects, as Federal Trade Commission Chairwoman Edith Ramirez has observed. But diversity in enforcement policy in itself is not necessarily bad. Progressives have long suggested that we rethink our antitrust policies to move beyond the excesses of the Chicago School of Economic Theory, as our former colleague, Senator Herb Kohl, has referred to it, to incorporate non-economic values that promote the public interest through enforcement policy. With this in mind, I commend our enforcement agencies for taking a long view in competition policy that embraces diverse antitrust frameworks and respects local autonomy, while also seeking to establish a fair, independent, and transparent enforcement process internationally. While most work remains to be done to broaden international consensus and ensure that enforcement policy is not just a tool for promoting domestic or industrial policy goals, I'm confident that we can continue to work productively to bridge our differences and complement divergent enforcement regimes. As we seek consensus, it is imperative that we avoid an exceptional view of our own enforcement practices if we are to build upon ongoing dialogues with other sovereign nations to establish economic and political comity. Indeed, progressives have long suggested a rethinking of our antitrust policies to move beyond what Senator Herb Kohl again referenced as the excesses of Chicago School economic theory, and that we seek to incorporate non-economic values that promote the public interest through enforcement policy. In closing, I thank the Chair for holding today's hearing, and I hope to continue to look beyond our own antitrust enforcement practices in future hearings. I also thank our witnesses for their testimony. We truly have a wealth of expertise on the panel. I'm looking forward to hearing your views, particularly on the issue of whether or not there should be just one regime, and it be our regime for antitrust enforcement. And when I say ours, I mean the American formula. And with that, I will yield back the balance of my time.
I thank the gentleman. It's now my pleasure to introduce the chairman of the full committee for his opening statement, the gentleman from Virginia, Mr. Goodlatte.
Thank you, Mr. Chairman. The Judiciary Committee routinely exercises its oversight authority to ensure that our nation's antitrust laws are applied in a manner that is transparent, fair, predictable, and reasonably stable over time. A natural extension of this oversight is ensuring that our nation's companies and citizens receive comparable treatment in foreign jurisdictions. As commerce becomes an increasingly global enterprise, the manner in which antitrust and competition laws are applied to companies and citizens located or engaged in business outside of the United States also grows in importance. In particular, China has risen in prominence as an economic marketplace as well as a competition law jurisdiction. Over the past several years, reports have surfaced that allege China is deploying its competition laws in a manner that strains the boundaries of due process, that focuses on advancing domestic industrial policies, and that seeks to extract valuable American innovations without fair compensation. I'd like to thank Chairman Issa for holding today's hearing to delve into these potentially serious abuses. Today's testimony will help the committee gain a better understanding of the history of China's competition laws, how they have been enforced, and the potential impact of this enforcement on other international competition jurisdictions. Furthermore, it will provide a record regarding how our executive agencies, including our antitrust enforcement agencies, have been coordinating among each other and engaging with China and other foreign countries on international competition law enforcement. This hearing also serves as a reminder that the United States should be a leader in fair and reasonable antitrust enforcement. To that end, enacting important antitrust reforms, such as the Smarter Act, will help to ensure that the U.S. continues to be an example to international competition law authorities. I look forward to hearing from today's excellent panel of expert witnesses on these important issues, and I yield back the balance of my time.
I thank the gentleman for his opening statement and his comments. If Mr. Conyers arrives, we'll take his opening statement in due course. But it's now my pleasure to introduce a distinguished panel here today. The witnesses' written statements will be entered into the record in their entirety, and I would ask each of the witnesses to summarize their testimony within 5 minutes. Since virtually all of you are pros, I'll summarize by saying the red lights work just like they do on city streets. Please look at them for the same indications of go, pause, go faster, and stop. To help you stay within that time period, please observe them. It's now my honor to introduce our witnesses, but before I do that, in concert with the rules of the committee, I would ask that all 4 of you please rise to take the oath. Please raise your right hands. Do you solemnly swear that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Please be seated and let the record reflect that all witnesses answered in the affirmative. It's now my pleasure to introduce Commissioner Olhauser. I always do this to you. I'm sorry. Olhauser. I do that every time, and I apologize, Maureen. Commissioner Olhauser was sworn into her position as a Commissioner of the Federal Trade Commission on April 4th, 2012, to a term that expires September of 2018. Prior to becoming the Commissioner of the FTC, the Commissioner spent 11 years working for the Federal Trade Commission in various capacities, including Director of the Office of Policy and Planning and Attorney Advisor to the former FTC Commissioner Swidell. She has spent a number of years in the private sector working on FTC issues and as a partner at the law firm of Wilkinson, Baker, and Connor, LLP. The Commissioner earned her bachelor's degree in English with honors from the University of Virginia and her JD from George Mason the newly named the Antonin Scalia Law School. I see somebody pick that up right away. Our next witness, Mark Cohen, is a senior counsel at the United States Patent and Trademark Office, where he leads a 21-person team focused specifically on the expertise of China. It's got to be a full-time job with just 21 of you. Mr. Cohen has over 30 years of private and public sector in-house and academic experience in the China transition economies, serving in such roles as the Director of IP for Microsoft Corporation and a counsel at the law firm of Jones Day, a Cleveland-based company of my youth, but worked in their Beijing office. In addition to his position at the Patent and Trademark Office, Mr. Cohen lectures at the university in the United States and abroad, including Harvard, Fordham, and the China University of Political Science and Law. Mr. Cohen earned his bachelor's degree in Chinese Studies from the State University of New York in Albany, his master's degree in Chinese Language and Literature from the University of Wisconsin, and his JD from Columbia. I'm impressed. Next, we have Mr. Sean Heather, Vice President, Center for Global Regulatory Cooperation and the U.S. Chamber. Sean Heather is the Vice President of the U.S. Chamber of Commerce Center for Global Regulatory Cooperation, which seeks to align trade, regulatory, and competition policy in support of open and competitive markets. During his 16-year career at the Chamber, Mr. Heather has worked in a wide range of issues spanning from international trade and antitrust to tax, technology, and corporate governance. Mr. Heather is also the co-author of the Chamber's comprehensive report on China enforcement and its competition laws. Mr. Heather received his bachelor's degree in business administration and an MBA, both from the University of Illinois. Last, and definitely not least, we have Professor Thomas Horton, Professor of Law, University of South Dakota School of Law. Professor Horton transitioned to a full-time academic position following a 28-year career as an antitrust lawyer, where he served at both the Federal Trade Commission and the Antitrust Division of the Department of Justice, in addition to partnership at several major international law firms. Professor Horton earned his bachelor's degree from Harvard, cum laude, his JD from, we're back to Cleveland again, thank goodness, Case Western Reserve, right there on the Near East Side of Cleveland, where their School of Law, and graduated with the Order of Colif, and a master's degree with honors in liberal studies from Georgetown University. Before I recognize the Commissioner, thank you for going to Case. That's everyone in my family either applied or went there. I went to Kent State. You can tell why. Your Honor.
Chairman Issa, Ranking Member Johnson, and members of the subcommittee, thank you for the opportunity to appear before you today. International antitrust law has been very dynamic over the past 2 decades. The FTC engages in multilateral fora and bilateral consultations. It also offers technical assistance to build stronger relationships with foreign competition agencies and to encourage convergence on sound, economics-based competition policy and enforcement. The global economy, competition, and consumers benefit when competition laws function coherently and effectively. Enforcement predictability also reduces the cost of doing business and improves outcomes for consumers. While the FTC's focus has been global, the agency has devoted significant attention and resources to 2 areas that have received particular attention in recent years: China's antitrust enforcement and the application of antitrust to intellectual property rights. I personally spend a lot of time on these issues. I've traveled to China 7 times in recent years to engage in dialogue, both formal and informal, on antitrust policy and enforcement, including attending a conference on antitrust in Asia in Hong Kong just last week. Even before the enactment of China's anti-monopoly law, or the AML, in 2007, the FTC and the DOJ worked with Chinese officials to promote predictability, fairness, and efficiency in antitrust enforcement. We have also stressed the importance of economics to sound antitrust policy. China's AML resembles the competition laws of the United States in many ways, including, for example, provisions on cartel conduct and anti-competitive mergers. The AML, however, also has important differences, including the prohibition of unfairly high pricing and consideration of non-competition factors, such as the effect of a merger on economic development. Our engagement with Chinese authorities on the development and implementation of the AML has produced some positive, tangible results. A good example is China's adoption of a simplified merger review procedure last year, which saves time and reduces costs for merging companies. We have also observed that MOFCOM increasingly sets forth its economic analysis in published merger decisions. Nonetheless, our efforts with the Chinese AML agencies are best seen as a work in progress, as there is continued concern regarding the procedural and substantive application of the AML. Issues raised by Chinese procedures include the degree of transparency, the opportunity to present a defense, and the ability to be represented by counsel. Due process is a critical element to ensure fair, transparent, and non-discriminatory application of antitrust laws. At the recent meeting in Hong Kong, I was particularly encouraged to see all three Chinese agencies acknowledge these procedural concerns. On a substantive level, there continues to be a belief that Chinese agencies are pursuing non-competition objectives through antitrust enforcement to promote domestic industries or Chinese competitors. We take such concerns seriously and have worked through multiple avenues, including our most recent Vice Minister-level bilateral meeting in April, to encourage China's agencies to ensure appropriate transparency and fairness. So far, we have seen some promising responses, including through the strategic and economic dialogues, as well as the U.S.-China Joint Commission on Commerce and Trade. In 2014, through these dialogues, China officially recognized that the objective of competition policy is to promote consumer welfare and economic efficiency rather than promote individual competitors or industries, and that enforcement of competition laws should be fair, objective, transparent, and non-discriminatory. Through these dialogues, China also provided certain commitments regarding AML enforcement procedures. We will continue to engage with Chinese antitrust authorities on these issues. International convergence on unilateral conduct remains a challenging area overall, particularly for conduct involving IP rights. Many of the concerns about IP-related enforcement have focused on China because its competition law prohibits unfairly high pricing as well as places limits on refusals to deal. The Chinese AML agency's current draft IP guidelines reinforce this concern with provisions that would create liability for refusals to license intellectual property deemed necessary to compete in a given market, as well as provisions that would prohibit unfairly high IP royalties. The FTC and the DOJ have voiced concerns over the potential danger of reducing incentives for innovation, not only in China, but globally, and have thus urged caution in enforcing these provisions. The FTC will continue to advocate for policies and approaches that promote innovation and competition as these guidelines continue to develop. Thank you for your time, and I look forward to your questions.
Thank you. It's now my pleasure to introduce the ranking member of the full committee for his opening statement, Mr. Conyers of Michigan.
Thank you, Chairman Issa, and I want to put my statement in the record.
Without objection.
And just note that today's hearing with these particular witnesses promises to be not only informative and timely, particularly with respect to China's enforcement of its anti-monopoly law, and I appreciate your comments in that regard. And over the last days, even, Treasury Secretary Jacob Lew, who was in China for the latest round of talks in the ongoing U.S.-China Strategic Economic Dialogue, makes our discussion here so significant and important. I commend the chairman for it, and I leave you with this one thought. What impact will China's alleged discriminatory enforcement practices have on American jobs. And I thank the chairman for his indulgence, and I yield back the balance of my time.
I thank the gentleman, and hopefully we'll see the answer to that question as we speak. With that, we go to Mr. Cohen for his opening statement.
Chairman Issa, Ranking Member Johnson, members of the committee, thank you for the opportunity to discuss competition law in China from the perspective of the U.S. Patent and Trademark Office. It's an honor to appear before you today. USPTO is engaged with China on all IP issues, including those that involve antitrust and licensing. Last year, Undersecretary Li met with Chinese Vice Premier Wang Yang, and just last week, I accompanied Deputy Undersecretary Slifer to Beijing to advance talks on critical IP issues. Along with the United States Trade Representative, Undersecretary Li also co-chairs the IPR Working Group of the Joint Commission on Commerce and Trade, or JCCT, to engage bilaterally on improvements to China's IP regime. Over the years, the JCCT and related dialogues have included several commitments on IP, including on standards, licensing, legitimate sales of IP-intensive goods, and judicial reform. The USPTO's China team consists of 21 people, including experienced IP attachés in 3 Chinese cities. We have signed agreements to support cooperative activities in IP with several Chinese agencies. We also frequently meet with industry to exchange views, educate them, and share their concerns. In our experience, the current environment for IP and antitrust in China has 3 pronounced characteristics. These are, 1, strong antitrust enforcement is counterposed against weak IP protection. 2, there's little foreign use of the IP enforcement system, while there's considerable foreign concern about being targeted for competition law violations. And 3, industrial policy in China makes it difficult to legitimately license technology to third parties. Regarding the first item, China's weak enforcement system, Chinese IP damages are too low, weakening fundamental protections IP right holders need. IP holders who run afoul of Chinese AML authorities often do not believe that their legitimate rights have been protected. In summary, China is pursuing IP abuse without first having adequately secured IP use. As an example of this unbalanced environment, the antitrust fine imposed against Qualcomm for $975 million is thousands of times more than the average damages in a patent litigation in China. Second, surveys and press reports suggest that many foreign companies feel targeted. While Chinese antitrust authorities have taken pains to show that they are enforcing their laws even-handedly, this sense of feeling targeted is coupled with little affirmative use of China's IP system, as well as concerns of over due process and a sense that foreigners' rights are not being adequately protected. As for the third item, industrial policy, I share the concerns of many here. Much of the problem with commercialization of technology today in China is due to an over-interventionist Chinese economy. Notwithstanding the international consensus that IP is a private right, China's state planners have created a wealth of interventions in IP creation and licensing, from which it is reasonable to assume antitrust policy is not excluded. These 3 serious problems highlight the challenges our companies face: weak IP protection, targeting, and industrial policy. The administration has pushed back on the more onerous aspects of these policies. USPTO has also taken a lead on highlighting challenges involved in licensing IP to China, including negotiating with our Chinese counterparts, training programs, and research. In summary, the administration strongly supports China's efforts to develop an antitrust regime consistent with the practices of other market economy countries. However, there are many aspects of China's economy that may not be fully market-driven in the context of both IP and IP-related antitrust. Thank you, and I look forward to your questions.
Thank you. Mr. Heather.
Thank you, Chairman Issa and Ranking Member Johnson, for today's important hearing and inviting the Chamber to testify. The Chamber's approach to antitrust is grounded in the belief that antitrust should be transparent, fair, predictable, reasonably stable over time, consistent across jurisdictions, and based on sound economic analysis. For the past several years, the Chamber has worked with China on its anti-monopoly law, and China has made some positive progress. In part, improvements can be traced to high-level engagement between the two governments. The Chamber welcomed the commitment by the two presidents during President Xi's state visit in 2015, where it was agreed, quote, both countries affirm the importance of competition policy approaches that ensure fair and non-discriminatory treatment of entities and that avoid the enforcement of competition law to pursue industrial policy goals. However, China's antitrust enforcement has yet to live up to this ideal. The AML itself allows China's agencies wide latitude to inject industrial policy into their enforcement activity. Further, stakeholders in China's government not directly charged with enforcing the AML have the potential to weigh in and steer the outcome of an antitrust investigation. As a result, in many cases, foreign companies find themselves at the victim of industrial policy goals that promote also discrimination and protectionism. Merger reviews have created opportunities for China's own national champions to expand and increase their market share, have capped prices for products and technology on which domestic companies rely, and protect famous Chinese brands from acquisition by foreign companies. To date, all merger transactions blocked or conditionally approved have involved foreign companies. Similarly, AML investigations have forced foreign companies that market consumer products to reduce prices, even when such prices appear to be the result of market forces rather than anti-competitive conduct. The Chamber is particularly concerned with China's ongoing efforts to develop IP abuse guidelines under the AML. Those guidelines endorse a broad, unbalanced essential facilities doctrine and impose stiff anti-monopoly sanctions for refusing to license IP or charging, quote, excessively high royalties. As drafted, the guidelines would force companies that possess critical technologies to license their intellectual property to Chinese competitors or to lower licensing costs to benefit local firms. As China concludes its drafting process later this year, the American business community hopes that China will remove its unbalanced essential facilities doctrine, delete provisions on excessive pricing, and eliminate provisions that prohibit or restrict the refusal of license. We believe such a course correction is ultimately in China's long-term interest as it seeks to move up the value chain and become a global innovative contributor. Let me mention a word or two about due process. Concerns regarding the substance of China's AML and its enforcement are compounded by continuing concerns over transparency and due process. Limited evidence is often presented to the target in support of vague or novel theories of harm. The absence of an independent judiciary as well as potential threats of retaliation deters companies from seriously considering an appeal. The results, more often than not, is an investigative process that incentivizes a foreign target of investigation to settle on terms favorable to the Chinese government. Looking beyond China, the Chamber actively follows upwards of a dozen jurisdictions annually. Many of the concerns we discuss here today exist elsewhere in the world to varying degrees. Today, it can be difficult to discern what is an appropriate international antitrust norm. Take a statement from the Korea Fair Trade Commission regarding its 2015 enforcement plan. It stated that one of its primary goals was to strengthen enforcement against global monopolistic enterprises holding original technologies having a significant influence in the Korean industry. The wording of such a statement demonstrates how perverse uses of antitrust can creep towards becoming an acceptable international norm. Last year, China issued a fine to Qualcomm for just under $1 billion. That amount may seem like a lot, but it is actually the third highest fine behind the questionable fines issued by Europe against Intel and Microsoft. China also raised eyebrows over the condition imposed on the Microsoft-Nokia merger, only for Korea to follow and place significantly more questionable conditions on that same merger. In these examples, China's actions can be seen to further stretch international norms, while also claiming to live within them. It also demonstrates that the world of international trust presents problems beyond China. In closing, the Chamber greatly appreciates the work of the U.S. antitrust agencies and this administration. Yet more work needs to be done. Let me conclude by highlighting some of the recommendations from my written testimony for Congress and this committee to consider. First, it is important to endorse a whole-of-government approach wherever antitrust is misused and abused. It is critical that competition policy advocacy vis-a-vis China occur within the framework of the administration's broader economic and commercial policy toward China, as set forth by the President of the United States. Second, Congress, through rigorous oversight should support the administration to do everything in its power to ensure provisions of China's IP abuse guidelines are at least as consistent with U.S., EU, and Japanese approaches. This must be a top and urgent priority. Finally, Congress should be more vocal in its support for addressing these concerns through bilateral investment treaty negotiations with China and through competition chapters in our trade agreements. Thank you, and I look forward to answering your questions.
Thank you. Professor Horton. Could you pull it a little closer to you so we could hear you? And make sure the light is on, the little button down in the middle.
Oh, there we go.
There we go.
Thank you. Chairman Issa, Ranking Member Johnson, distinguished committee members, council, and staff members, thank you so much for inviting me to testify here today. And thank you, Chairman Issa, for your kind words about Case Western Reserve University and Northeast Ohio. To understand China's anti-monopoly law and its recent enforcement efforts, it's necessary and crucial not only to carefully examine the words of the anti-monopoly law, but to read them in the context and light of Chinese history, culture, and traditions. First and foremost, we must recognize that China may be the only civilization the world has known upon which Western thought exercised little or no influence until modern times. China's historical culture was largely independent of Western influences, and its responses to its people's economic needs are often peculiar to China and sharply differentiated from other countries. Second, it's important to keep in mind that China's political system does not share our values of Western legal traditions. China is not in any sense a Western-style democracy, and in reality, the country still is without rule of law. Furthermore, the leaders of the Chinese Communist Party are not interested in bringing about a change of allegiance by bringing Western political systems to China. Consequently, China's anti-monopoly law enforcement activities ultimately are not directed towards carrying out or reinforcing Western neoclassical economic ideologies, but towards helping to protect a socialist rule of law system with Chinese characteristics. China's determination to chart its own antitrust course without following or adhering to Western ideologies has resulted in 4 major trends during the first 8 years of AML enforcement. First, China aspires to protect and buttress its economy by safeguarding what it perceives to be fair market competition in the consumer and public interests of China's citizens. Second, China is determined to protect at all costs its own perceived long-term security and economic interests. Third, China is focused on protecting its indigenous business and entrepreneurs, including its diverse multitude of small and medium-sized businesses. And fourth, China is demonstrating a strong propensity to focus on potential barriers to entry and the use of exclusionary practices. Ironically, echoing the comments of Representative Johnson, America would be well served by following similar objectives in our antitrust enforcement policies instead of continuing the current under-enforcement of antitrust laws, which have led to alarming levels of concentration and diminished competition in industry after industry. Rather than simply criticizing China and trying to lure it into following current neoclassical American economic models, we should humbly ask ourselves whether we might learn from the Chinese and their Confucian traditions and values. On one hand, China should be lauded for promulgating an aggressive antitrust policy that takes into account Confucian norms of ethics, morals, and fairness, and seeks to inspire increased corporate social responsibility. We would be well served to pursue similar objectives. On the other hand, as stated here by the other witnesses, the Chinese and their antitrust enforcers are going to need to pay more attention going forward to their own Confucian traditions and values. Ongoing business and governmental corruption in China must be aggressively addressed. Furthermore, the Chinese need to acknowledge and realistically address the pressures on their AML enforcers to aggressively target foreign companies in order to protect and bolster indigenous Chinese companies and businesses. And finally, the theft of IP and IT to bolster the Chinese economy must stop. Instead of trying to pretend that they're acting neutrally and objectively in their AML enforcement, the Chinese need to find better ways to focus primarily on competition policies as opposed to industrial protectionism. As always, the future is uncertain, but the stakes could not be higher. Whether we like it or not, China's and our economies are inextricably linked and positively correlated. Both China and the West must continue our ongoing dialogues and seek to continue building strong economic, cultural, and political bridges. After all, much more than future international antitrust enforcement is at stake. Thank you.
Thank you. We now go to the gentleman from Georgia for his round of questioning. Mr. Collins.
Thank you, Mr. Chairman. I want to take this moment, just sort of broaden out the picture just a little bit, and I think is what we're looking at, and it's sort of open question to all. I think we all can understand that China, and was even the last Communist organisation, is very protectionist, very looking after themselves, but yet at the same time wanting to aggressively market everywhere else in the world. Okay, we can understand that from even from a capitalist standpoint and looking at that. The problem I'm looking at is, especially in this area of IP, I mean, this is a country that has have its own, quote, state-owned business moving factories out of mainland China to other areas in the Middle East to keep their own theft from occurring. So I think we've got an issue here. But I have just a general question, and it was mentioned in a couple of your comments. In the area of trade, in the area of working with the world, with the negotiations of the TPP and with the past few years of the AML, what do we see in China in regard, have you seen an uptick in the protectionists? I know I have seen in some areas in maybe a response to the other countries in the TPP. I'd like to get your, just a perspective, maybe an overall perspective on that. And anybody wants to start, Madam Secretary, or whoever, instantly start. Mr. Coyne.
Maybe I'll take a first shot at that. Obviously, USTR is the lead on negotiating the TPP. In our bilateral discussions, China has expressed an interest in the TPP, although I think its primary focus is on its own internal demands and needs. And I think in that area, we do see a heightened level of technical interest and engagement on intellectual property, primarily because China wants to become an innovative economy. And that's really shaping its engagement globally.
And I want to just bring that up, and again, feel free, it's a matter of discussion. But you just brought up to be an innovative economy. I think, are we seeing other problems here when you're looking even outside and even internal estimates of their growth and the issues of their economic growth, which is at best stagnating, at best from the norms of where they were basically government? What are we seeing, when you say of innovation, and where are we seeing the innovation? It still seems that they're copying a great deal and then protecting it as it comes along. Is that an unfair statement, especially in a restrictive economy at this point?
I think the good news is China is interested in innovating, and the bad news is China is interested in innovating. The good news is that hopefully it will help foreign rights holders and foreign companies if they can compete equally and fairly. And in some areas, China is achieving some measure of success. High-speed rail, for example, some of the research in the life sciences, and we've seen a lot of activity in patenting. But there's concern that in the process of seeking to become an innovative economy, the field won't be balanced or fair, and that foreign entry could be restricted.
Well, and I think that's what we're saying, Mr. Horton and Mr. Heather, to say this. The interest is not, to me, creativity, and what we've talked about in this committee a lot, is creativity is thinking something new. Creativity is not seeing my pencil and then copying it and painting it red instead of yellow and calling it creative. That's not creative. And I think that's some of the concern. But the other concern is using this, I'd like to hear from the two here, is taking this idea of protection, but also then taking companies that have made innovative strides, have went into China to actually work, where it becomes more of an economic disincentive. They're saying you're taking over, and then all we're doing is rate manipulation at that point. Ms. Heather and Mr. Horton, I'd like to hear your comments on that.
Yes, I am responsible for the Chamber's antitrust policy. I'm not our China expert who's actually in China, but I think if he was here today, he would share with you the way the Chamber looks at it is outside of the antitrust realm, that there are a range of Chinese policies that are all geared towards kind of industrial policy means and ends. And therefore, the antitrust law in some ways runs counter to those larger policies that the Chinese government is advancing, and therefore opens up itself to the opportunity to advance those industrial policy goals. It's also important to, I think, note in the China context that the three Chinese agencies, NDRC, MOFCOM, and SAIC, all have other missions within their jurisdiction that are much more central to the way the Chinese organize and operate their economies, and the AML function that they fulfill is kind of on the margins of what is their core responsibility, which is more in this industrial policy vein. As it relates to IP protection and these things, I think there's a number of avenues in which the U.S. government and the Chamber have been advocating by which to eliminate forced tech transfer of U.S. companies where they go into China, and then as a condition of investing in China, as a condition of operating in China, they are required to somehow joint venture with a state-owned enterprise to pass off their technology in some way, shape, form, or the other. There's a number of ways in which we're working to try to combat that, including through negotiations of a U.S.-China bilateral investment treaty.
That's it. Mr. Horton.
I grew up in a family where I was indoctrinated as to the importance of the patent laws. My father has 39 patents in the ceramic engineering field, primarily for the use in aircraft engines. And so I believe that the patent laws are amongst the most important laws stated in our Constitution that Jefferson wrote into the Constitution. The bad news for the Chinese and why they're stealing IP is that their innovation is not happening from their large state-owned enterprises, and their institutions are not producing enough good research. They're filing more patents than anyone in the world, but most of them are sham patents that have little value. The good news for the Chinese, and what we might think more about emulating, is that they have a growing bamboo capitalism of small business and entrepreneurs, and really new innovations, new patents, new ideas come out of small companies. They come out of the garages. They come out of the Bill Gates working in his garage. They don't come out of the big companies. And so the Chinese are seeking to protect their small businesses, something we've gotten away from in the United States with our antitrust policy, where we've allowed and even encouraged dominant firms with heavy market concentration who then can make monopolistic profits that they don't put back into research. So we should emulate the Chinese in protecting our small businesses, entrepreneurs, and doing everything we can to encourage them.
Mr. Chairman, I yield back.
I thank the gentleman. We now stay with Georgia and go to the ranking member, Mr. Johnson.
Thank you, Mr. Chairman. Professor Horton, are there any other lessons that U.S. antitrust policy can take from China's antitrust enforcement efforts?
Yes, I believe that there are. First, I think that in areas like monopoly leveraging, resale price maintenance, where our Supreme Court just a few years ago in the Legion case overruled on a 5-4 basis more than 100 years of sound antitrust policy under the name of neoconservative economics, under predatory behavior by dominant firms. I think the Chinese are very progressive and ironically could end up being leaders in world antitrust enforcement if we in the United States do not become more progressive and put behind us the 40 years of neoclassical economics that have led us astray and that are really a key part of what we're hearing in today's current election cycle about all the unfairness that's endemic in the American economy.
What say you to that, Mr. Heather?
I think that we're talking about apples and oranges. The Chinese system is one that doesn't have rule of law, which I believe Professor Horton referred to. And so I think any discussion about what policy debate we may have in the United States about the role U.S. antitrust law should play in our market is not akin to what happens in China.
Well, I guess there are enforcement mechanisms without an independent judiciary. They're made in a different way. But Professor Horton, any rebuttal from you as to Mr. Heather's comment?
Mm-hmm. Well, I think that the Chinese anti-monopoly law, where it's very sound and progressive, is it talks about fairness, fairness to consumers, fairness to competitors, and a stable economy.
Yeah.
And we seem to think that fairness is some kind of mushy idea that has no place in economics. In fact, fairness is fundamental to a sound economic system, and the Chinese recognize that. We need to get back to that.
Now, our independent judiciary, Mr. Heather, does it have fairness at its as its benchmark of making decisions, or does it? I mean, what do you say to that? To what Professor Horton just said, the ideals that we apply our antitrust policies. I mean, what is there, can we learn something from the Chinese in terms of adopting ideals such as fairness to consumers?
Well, given the fact that we've had the due process concerns in China's antitrust proceedings, I think it's ironic that we're talking about, or you're depositing the question whether or not we can learn anything about fairness from China. I think that certainly I expect our judiciary to provide fairness when anyone goes before it. But I think the question that underpins this is whether or not the Chicago School of Economics is the school by which the U.S. antitrust laws should remain guided or be informed by. To that point, in referencing that in the context of China, it's one thing to make these kinds of broad statements. It's another thing to have the rigorous economic analysis to support them. And none of the cases that we see coming out of China has an economic proof to go with the statements that they make. And I think that regardless of where we want to take U.S. antitrust laws, which have changed over the last 100 years in terms of how they're interpreted, and I suspect they will change over the next 100 years, there will still be a requirement in the U.S. system to underpin that with rigorous economic analysis, because it's not just about the law, it's about the economics.
And our courts apply rigorous economic thought to its decisions on antitrust policy? Yes.
I believe they are do so in most cases, yes.
I guess it depends on what school they are trained from, perhaps. But let me move on. China issued some regulations today on electronic payment services, and as global payment networks prepare to establish payment processing services in China, they potentially face impediments under these new rules, which I've not seen. I don't know if any of you all have, but the potential is there. They will be required to implement Chinese security and encryption standards rather than globally interoperable security standards, which are well established and internationally recognized. How can the U.S. continue to push for competitive access to the Chinese market while protecting the integrity of the international payment system in light of divergent security and encryption standards? Mr. Cohen, let me ask you that question.
There have been longstanding concerns about market access for payment processing and for encryption and security standards that have been raised for a good 10 or 15 years, and we've been raising them bilaterally as potentially discriminatory treatment of U.S. companies and U.S. rights holders, and in some cases demanding forced transfer of technology, with some successes to date. I'm not familiar with the latest rules. My office has mostly been concerned about forced transfers of intellectual property or adopting standards that primarily rely on China's indigenous innovation and would thereby discriminate U.S. innovation and U.S. technology.
What do you say to that, Professor Horton?
Well, I would be concerned about the Chinese interoperability standard, because I do think that the Chinese are very cognizant of their own security interests, and one of the big problems with the IP and IT theft has been the concern that this is going to Chinese military technology. So I think that we should put tremendous pressure on the Chinese to not allow their own indigenous system that they might take advantage of to be the standard for operating in China. I think the House here could put increasing pressure on China, as could the executive branch, to turn their own Confucian values around and say, you have to be fair towards the rest of the world, not just your own consumers and public.
All right, and Mr. Heather.
I'm aware of the regulations you mentioned, but our China team would be more prepared to comment and answer questions you have that we can have follow up with your staff.
Thank you.
Thank you.
Ms. Olhausen, I'll get to you next time.
We'll now go to the gentleman from Michigan, Mr. Bishop.
Thank you, Mr. Chair, and thank the panel for your insight today. I wanted to, having a chance to review some of the recent reports highlighting the problem of Chinese companies using stolen images and deceptive advertising to lure American consumers into buying poor quality apparel direct from the Chinese manufacturers. And that said, Mr. Chair, I'd like to ask unanimous consent that be able to submit this document, which depicts blatant pictorial examples of Chinese advertising
without objection,
using
unanimous
stolen
consent
images.
will be granted.
These images are so blatant and lawless. There's no incorporation of any Confucius laws of anything, especially ethics or fairness. American companies are increasingly discovering that copyright images being used in advertisements on sites like Google and Facebook are preying upon Americans and the American consumers. When the customer receives the item, they look nothing like the picture they saw online in the advertisement. The clothing items are typically made of inferior material. They're constructed cheaply, and they arrive in sizes that oftentimes are nowhere near and probably just big enough to fit a child. We all know that customer service as well is non-existent, and the American buyer has no option whatsoever for returning the product or getting a refund. These false and misleading advertisements using stolen images result in consumers receiving merchandise far below the quality they're expecting and threaten the competitiveness and sustainability of American clothing companies, which we all know are in great jeopardy right now anyway, trying to compete. So I'd like to, if I could, refer this question to Commissioner Olhausen and Mr. Cohen, and I just would like to know what steps you're taking to eliminate this practice by Chinese companies in order to protect American consumers and to protect the intellectual property of American companies and prevent this kind of activity by Chinese companies in the future.
Thank you, Congressman Bishop. So the FTC, as you know, in addition to our antitrust authority, is also a consumer protection agency. And so we work internationally with other consumer protection authorities to address these kinds of issues. Now, there can be a challenge for how do you reach a company in another country if they are, what is their contact with the U.S. So to the extent we can reach companies that are misleading consumers, if they have some presence in the U.S., then we can try to bring an enforcement action. Otherwise, we need to work with our international counterparts. I would say our relationship with the consumer protection authorities in China is not as developed as they are with the consumer protection authorities in Canada and Europe and some other more developed economies. But we continue to try to work and build these kinds of relationships.
So if I may, Congressman, the problem of counterfeit and shoddy substandard goods emanating from China is well known. Chinese exports are accountable for about 80%, if I remember correctly, of U.S. seizures of infringing goods. There's a lot of litigation both within China and outside of China owing to China's manufacturing and sales of counterfeit and substandard goods. Under the JCCT rubric, there's a commitment by the Chinese to work on reducing the incidence of these goods. We've been trying to work with platforms such as Alibaba, JD.com, and others to address this problem. The first recourse is, of course, voluntary steps taken by legitimate platforms to take down the goods, to respond to complaints, and to respond to the complaints not only of consumers but of rights holders who observe the counterfeit goods. There's a huge magnitude to this problem in terms of the growth of the platforms, the sales coming from overseas, the facility and ease with which the goods can be distributed, including via small parcels, which are hard to detect. And it's really an issue that skips many different agencies within the U.S. government and the Chinese government, including our own Customs and Border Protection, our FBI, state and local enforcement, the PTO, U.S. Trade Representative, Federal Trade Commission. So it requires a lot of coordinated effort, including working with our rights holders and consumers to address the problem. But it's going to take time and considerable effort.
Thank you very much for your answer. Mr. Chairman, I yield back.
I thank the gentleman. We'll now go to the gentleman from Texas, Mr. Ratcliffe.
Thank you, Chairman. I appreciate all the witnesses and your testimony today. I think this topic is especially timely given the U.S.-China strategic and economic dialogue that's taking place this week. The trends that we've seen with respect to China enforcing its antitrust laws to advance its own industrial policies are troubling, to say the least. In fact, it's difficult to imagine China having a truly objective antitrust law when the very text of that law states that its purpose is to promote a socialist market economy. But even more telling, I think, are the anecdotes that we see from American and European companies, which in some cases are frankly shocking. We've seen reports of intimidation tactics, bullying companies into accepting punishments without full hearings, and even in some cases companies being told not to challenge their investigations or even bring their lawyers to some of the hearings. Beyond the direct impact of China's behavior on American companies, I'm a little bit concerned that other rising economies out there will see China's behavior and perhaps follow suit. So the bottom line is, I think that if China wants to be taken serious as a leading economy, then these issues need to be addressed or remediated. Mr. Heather, I want to start with you. I appreciate you being here to testify today. I know this can be a sensitive issue within the U.S. Business community, and I know some folks may actually fear retaliation for speaking up and voicing their experiences. So I appreciate you being here to speak on behalf of U.S. companies. Let me start with what I mentioned before, the U.S.-China strategic and economic dialogue. What meetings and conversations do you hope that our administration is initiating in that regard?
Well, I believe that the SNE&D has come to a conclusion in China, I think as of this morning. I believe outcomes statements from those meetings were posted late this morning. I do not believe there were any new developments coming out of this SNE&D related to competition policy. That being said, I think the SNE&D and the JCCT have been enormously helpful in particularly addressing those egregious due process concerns that you mentioned. In fact, I think most of the folks I talked to would say that it's probably been a year since those most egregious practices have been communicated back to the United States. So there is an effective dialogue there at the highest levels of the United States government with China, and China has shown some responsiveness. That being said, in my testimony, I said there are still due process concerns with a company being able to understand what the theory of harm is against them, being able to see the evidence China has collected so they can mount a defense and respond to that evidence. So there remains many due process challenges in China, but those most egregious offenses that you referred to in your comments are things that, at least for the last year or so, seem to have subsided. And you can track that pretty closely with these high-level commitments that came out of the SNE&D and the JCCT.
Well, I'm glad to hear your perspectives on that. Let me ask you this question. Are there areas of United States broader economic and commercial policy towards China that you think might be exacerbating some of the concerns that we're talking about today?
I think the answer to that is absolutely. As I testified, that the AML can be used as a force for good in creating greater competition within the Chinese market, but the legal framework that is the anti-monopoly law also allows for supporting the social development of the market economy, as they refer to it. It carves out space for their state-owned enterprises and does a number of other things that provide unique twists on what antitrust enforcement would be in the United States, being consumer welfare focused.
Thank you. I'll move on quickly with my remaining time to you, Commissioner Olhausen. In your testimony, you talk about China's agencies pursuing non-competition objectives through competition enforcement to promote certain industries or particular Chinese competitors. You also talk about the fact that the FTC is working with other agencies within our government to advance consistent cooperation enforcement policies. I want to ask you in my remaining time, what is the interaction with the other agencies, and more particularly, are you receiving any pushback at all, or a message that maybe you need to stop or back off a little bit with respect to China for the sake of U.S.-China relations?
So we work closely with the Department of Justice, Department of Commerce on these issues. And what we try to do is give advice to the antitrust agencies in China as fellow antitrust enforcers, so that we can engage with them on like an expert-to-expert kind of dialogue. I don't think we've gotten any pushback about what we've been doing or what we've been saying from other parts of the U.S. government. Now, when I've talked to Chinese officials, we certainly have to be sensitive to the fact that their laws do allow for some non-competition factors to be included. But one of the things that I've specifically advocated, and it's consistent with the general U.S. position, is if they are taking non-competition factors into account, they should be clear about that. It shouldn't be just rolled up in a competition analysis so that we don't know what part is competition and what part may be some kind of industrial policy. So at least as a first step, be transparent about the reasons for their decisions. As a later step, it would be better to remove those kinds of non-competition factors from an antitrust analysis completely.
Thank you, Commissioner. My time's expired. I yield back, Mr. Chairman.
I thank the gentleman. I'm going to follow up where that left off, though, Commissioner. China is part of the WTO, right? So any subjective, unwritten, we just win, you lose, is subject to a challenge, isn't it?
I'm not a trade expert, but I think that's correct. Certainly, they have to make commitments.
Right. But you're an expert on unfair trade practices.
Yeah, unfair trade practices being like antitrust and consumer protection kind.
Right. But as the chief watchdog of consumer protection,
Yes.
Domestically, what they're doing of injecting non-defined subjective standards is in fact the kind of manipulation that you investigate in private enterprises all the time to find out how these unpublished wrong, selective interpretations go on, right?
Right. Well, so certainly in the U.S., our antitrust law has evolved so that we only consider competition factors in a competition analysis.
That wasn't the question, but
Okay.
I'll go to Mr. Cohen.
Okay.
The Federal Trade Commission regularly goes after people with false and deceptive practices, implying that you can win when in fact you can't. The WTO does require that there be essentially a transparent policy, and protectionism is inherent, not tariffs, but protectionism is inherently barred within the WTO, and an administration, our government, can sue, as we are sued, if somebody believes we've crossed that line, correct?
As long as it offends a WTO requirement, that's correct.
So, in the case of Mr. Ratcliffe, his examples, the examples of this dialogue of antitrust being mixed with, well, we just want our companies to win, that in fact could lead to WTO action, couldn't it?
Again, the lead agency here is USTR, which is not represented. The WTO disciplines on antitrust are rather limited. There are certain provisions in the TRIPS agreement regarding...
Actually, I wasn't talking antitrust. I was talking about other subjective standards that are causing determinations to be made that are inconsistent with the actual antitrust laws.
If there are, perhaps if there are external influences that are inconsistent with the WTO requirements, such as national treatment or most favored nations treatment in investment or market access, and those could be cognizable trade issues.
Thank you. Let me follow up with, I'll make this sort of a general question, but I think it's directed to the Commissioner primarily. Is it fair to say that active engagement, and I'll use a term that's my term, not yours, calling out China for its double standards on intellectual property and on antitrust, calling them out in a respectful way, but consistently and aggressively, if you will, at least behind closed doors, isn't that an essential part of what we have to do at a minimum to keep China's inherent policies from tipping the scales against us? And I want to be careful. I'm not necessarily an expert on Confucianism, but I'm not at all, actually. But it does appear as though China only does that which we push hard to make them live up to. Is that a fair statement, somewhat in your estimation?
Well, I do think it's been important to have an honest but respectful exchange with the Chinese officials about where there might be deficiencies in their system or where there have been some inconsistencies. So, for example, when the U.S. Chamber put out their report in 2014, the Chinese agencies had a press conference where they pushed back and they said, no, we're not administering our law in an unfair way. But what was important is they then continued to engage with us, and we saw not just words but deeds followed on by that to have some improvements.
And you keep using the word respectful, and I think that's critical. This is a large trade partner, but I'm going to ask respectfully each of you to answer yes or no. Is it true that China is abhorrent in their respect for intellectual property, both patents and particularly copyright and trademarks? Commissioner?
Are they, I'm sorry, I missed the word abhorrent.
Abhorrent was the word I used, but deficient, quite deficient by international standards. Is that fair to say?
I think it's fair to say that they're weak.
Okay. Would you go further, Mr. Cohen?
Yes, they're somewhere between weak and abhorrent. In some areas they're improving, but the track record is very bad.
Yeah, and I'll go with the improving, but I'll stick with the abhorrent too. Mr. Heather, you certainly represent a huge amount of companies that are constantly frustrated. Would you use the word abhorrent, deficient, regardless of improving, below international standards of many developed countries?
I won't worry about the adjective. I will just simply say yes, China's enforcement of intellectual property rights is substandard.
Thank you. Mr. Horton, Professor Horton.
I would say seriously deficient. Addressing your comment quickly, the United States enabled China to get into the WTO. The United States has been China's best economic ally in promoting its growth and helping it, and the United States is still the greatest economic engine on the face of the earth. So if the United States stands up and tells the Chinese, look, you have to treat us with the same kind of fairness and equal rights that you want to instill in your own anti-monopoly laws, that's what's going to take if you want to continue having shipload after shipload of goods come here into the United States.
So you're good with we should speak regularly and affirmatively if we're going to have them behave?
I would say we should follow Teddy Roosevelt and speak softly and carry a very big stick.
I thank the gentleman. I now go to the gentleman from Georgia for a second round.
Thank you, Mr. Chairman. Ms. Olhausen, what has been the relationship between the FTC and, if you know, Department of Justice in terms of the Chinese antitrust enforcement authorities? Have they reached out? What is the relationship between your agency and DOJ, if you know, and the Chinese enforcement agencies, and if you could describe that relationship, if any?
Certainly. We signed a memorandum, so the DOJ and the FTC in 2011 signed a memorandum of understanding with the 3 Chinese antitrust agencies. And what that does is establish a framework for cooperation and dialogue between the U.S., the senior competition officials in the U.S. and in the Chinese agencies. We also developed a guide for case cooperation, so on particular cases where we are investigating, the U.S. agencies are investigating, and the Chinese agencies are, or a Chinese agency, usually MOFCOM, is investigating. Can we talk about it, or can we talk or coordinate in some way? So that's some of the more formal ways that we do this, and under the Memorandum of Understanding, we have regular high-level meetings. We also have a lot of informal engagements and talks, and so, for example, as I mentioned, I've been to China on numerous occasions, often to meet with these officials and to talk with them to further understanding, to raise important concerns that we might have about their enforcement.
So would it be safe to say that improvements are being made in terms of Chinese acknowledgement of American ideals in terms of antitrust enforcement, and also with respect to intellectual property, if you could comment about that?
So I think there are improvements being made. I don't think we are, close to saying, all the problems are taken care of. I do think that there has been progress. It's been slow. It's been very incremental. And one of the things that we often try to talk about, I often try to talk about, is why these approaches, the U.S. approaches, are not just that they're good for the U.S., but they're good for the Chinese economy. Certainly the Chinese officials rightly are caring about the Chinese economy and their growth and their innovation. And so I think it's incumbent on us to explain to them why our approach will lead to the best outcomes for their economy and for their movement from a manufacturing economy to an innovation economy. So protecting IP rights can help their own industries advance, their own industries invest, and have them become stronger players in an innovation model. So I think that's part of the important part of the dialogue. And when we point to the problems with them devaluing IP rights, it's not just that it may hurt U.S. companies, but it may hurt their own economy in the long run.
So this kind of dialogue between an advanced nation such as America and a developing nation with respect to China, is this the way to go, or should we, you said carry a big stick, Professor Horton, is there a different way of approaching this than the way that we're doing it now? Would you recommend another approach, Professor Horton?
Well, first, we have to recognize that we're dealing with essentially a dictatorship. The Chinese Communist Party is not in any way, shape, or form a democracy as we know it here in the United States, and that kind of government goes back thousands of years in China. So we're coming to any negotiations with China from a very different perspective and standpoint. Putting ourselves in the Chinese Communist Party leaders' shoes, they see all the changes that are transpiring in the world. They fear what was happening in Tiananmen Square. They fear the spread of democracy in China. And so on the one hand, they're trying to tamp all of this down while at the same time creating this economic miracle that can help keep them in power by giving more money and goods to the Chinese citizens. So I think on the one hand, we need to step back and say we're dealing with the Chinese from a very strong position. We have a very sound fundamental democracy. We have a very sound fundamental economy. We have excellent allies throughout the world. We have excellent trade relations. So we should not be intimidated by China's growth or its 1.5 billion people. We should go into any negotiations with the Chinese and say, look, you know, we helped defeat the Japanese in World War II to liberate your country. We've been good allies with you. We've helped build your economic miracle, but you have serious, serious problems in terms of dealing with the rest of the world, and it's in your interest, as Commissioner Olhausen said, to step up to the plate and recognize this if you want to go forward as a sound economic partner throughout the world.
All right, I thank you, Professor Horton, and I'll yield back. Thank you, Mr. Chairman.
Thank you, and I'll be a brief second round. Mr. Cohen, you were shaking your head during quite a bit of that in a positive way, so I thought I'd follow up it a little bit. There is a government in China that looks out for China. Is it fair to say that one of the challenges that businesses face, two of the challenges businesses face, one of them is a Chinese-centric, how do the Chinese view intellectual property? How do the Chinese view competition? Which is a sort of a business-to-business one. And then there's the government's desire to, if you will, protect its progress. It used to be it's 10%, but whatever number it happens to state that it can achieve that. Is that fair to say that we have two pots there to deal with?
I think that's a fair assessment. In fact, in innovation, we see state-driven innovation and private sector innovation of the type that Professor Horton has mentioned is another example of that, one coming from the top down and one from the bottom up.
So when we have, as Commissioner Olhausen is dealing with, government-to-government activity, I presume that we're dealing then with two sets of problems. One is that which the government controls directly, which is their policy and procedures, their execution of laws, and then that which really has more to do with the very strong provinces and more local authority that often, it's like pushing a string, if you, in my own words, that you can't necessarily expect the government to control, but they can attempt to make a difference. Is that a sort of a fair assessment of the China that we're dealing with, that which they control, that which they influence?
There is, I mean, China's not a unified state. It's not a federal system, but you know, there is that saying that the emperor is far and that in the provinces there's a little bit less control. But people still roughly follow national guidelines, and the structural weaknesses, such as the intervention of the party, is pervasive. The courts are no more or less independent than any part of China because the party is still very active there serving its interests.
Well, you know, there's a lot of lawyers here at the table, so isn't it true, as it was more than a decade ago when I was with the late Henry Hyde in China, that they have practically no lawyers educated in the sense that we think of members of the bar?
The legal community has been under a lot of attack in China. They have educated a lot more lawyers, but many of the human rights lawyers have been thrown in jail. Many of the outspoken lawyers have suffered repercussions. But at the same time, the courts are proceeding well in a technical sense. So you have a very interesting moment in time where the courts are under pressure, yet at the same time, technically, they're improving their expertise in a range of areas.
Well, when I was there with Henry Hyde, who made a major address, the number at that time was barely into double digits, sort of 10% of judges actually were lawyers. That unfortunately the court system was being administered by people who had not been trained in the law.
Yeah, I think that's no longer the case.
So it's risen.
It used to be the case that the judges were all former military officials. They've since had to take an exam, and they've gotten legal training, and in many cases, they not only have basic law degrees, but graduate.
So that's a good news
statement.
Last question. I started with you, Mr. Cohen, and I want to follow up one more time. We, the United States, led the way toward most favored nations and then WTO ascension for China in the hopes that they would, after receiving it, then comply better with what they were not complying with ahead of time. And we talked about antitrust laws getting mixed with other non-competitive or foreign competition dissuading. What kind of a grade would you give China on how well we achieve that goal by giving them WTO in hopes that they would live up to a standard you're supposed to have before you become a WTO member?
That standard was to have a rules-based trading system, transparency, independent courts. At least that, I think, were the aspirations. That is still very much a work in progress.
Okay. Professor, as a Case Western graduate, like my brother, who did get admitted, last question for the whole panel for you. You see China, and you have some serious doubts, and you were very outspoken in that. Is it fair to say, though, that disengagement would, in fact, by definition, allow them to keep doing what they're doing? Engagement, with some of the caveats that you presented here today, is ultimately the answer for how we have our largest trading partner do better?
I think the Chairman's comments today have been quite astute. We have no choice but to engage the country that has approximately 18 to 20% of the world's population. China's not going to go away anytime. It's going to increasingly influence what's happening throughout Asia and the world, and we should not be afraid of engaging with China. We have a very strong, fundamentally sound democracy and economy. We have nothing to fear from strongly engaging the Chinese, and over time, perhaps heading them towards the course of democracy. You know, we remember when communist China or communist Russia broke up. How did that happen overnight? No, I think it was decades of public pressure and subtle pressures, and just the people there seeing that there's a better way of life. And the Chinese are traveling all over the country. You can look here in this hearing today. They're here by the dozens, and they see that the United States open ideal of democracy and freedom of speech, freedom of religion, these are wonderful guideposts for the future. And let's hope that over the coming decades, the Chinese will slowly begin to realize that and move closer to a democracy.
Thank you. In closing, I guess I'll own up to the fact that I made my first trip to Hong Kong as a buyer in 1982, and made several hundred trips before I retired to come to Congress. I have great respect for the Chinese people. I had great respect for the Hong Kong business model and the governance that they managed to turn into a world standard of best practices. I appreciate the fact that the Chinese think of things in 10,000 years. We think of things in our couple hundred years, and apparently that's one of the reasons they're in less of a hurry than we are to achieve the goals. And I don't say that to be pejorative. I have great respect for where China has come so far. But this concludes our hearing for today. I want to thank all of our witnesses. You were all incredibly good. I want to particularly thank the Chamber for representing so many companies who, by definition, would prefer to have the Chamber speak on their behalf than to speak individually. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses and additional materials for the record. And with that, we stand adjourned.